These are the Water Boys, and this is their hit record, Fisherman's Blues.
I wish I was a fisherman, tumbling on the seas.
It made it to number 3 on the modern rock charts back in the 80s. Around the same time, the Supreme Court adopted an important legal doctrine that, 40 years later, would give real fishermen the blues. It's called
the Chevron doctrine,
also known as
the Chevron deference, which for 40 years has likely been the most frequently cited case in administrative law.
It directs courts to defer to federal agencies when interpreting unclear laws.
Here's what's giving today's fishermen the blues. There's a law that requires commercial fishing vessels to have federal monitors on board to make sure they aren't overfishing. But the law doesn't specify who pays for the monitors. So the agency decides it's the fishing companies.
You got to put these folks up in a cabin on your boats. These people are going to be monitoring you. They're going to be measuring these fish. They're going to make sure you don't overfish. You have to pay their salaries.
Under Chevron deference, the federal agency that oversees an industry gets to make the call, as long as its interpretation of the rule is reasonable. 2 different groups of fishermen sued, and their cases made it to the Supreme Court.
The Supreme Court will hear arguments on a case that could affect the independent authority of every federal agency in the country.
Congress enacts statutes and it tells agencies what to do, but it can't possibly fill in all of the details. So the question about the Chevron doctrine is, how much leeway does an agency have to fill in those details?
Let's start from the beginning. The year is 1984. The Supreme Court is considering a case about whether the Environmental Protection Agency has the authority to interpret what Congress intended in the Clean Air Act. The court decides that it did.
A key administration policy that eases air pollution rules was upheld by the Supreme Court today.
The justices said yes to a policy that allows a factory to build a new smokestack that increases air pollution
as long as the overall plant output remains within the clean air standards.
Justice Stevens, who was the author of the opinion, didn't consider it an important case at all, and that frankly that view was shared by all of the justices who were sitting at the time. It's actually a pretty darn important decision.
Richard Pierce teaches administrative law at George Washington University. He's a bit of an expert.
Yeah, I've been teaching the subject for almost 50 years now.
So what makes Chevron so important?
It was much more simple and more deferential.
Chevron gave courts a clear roadmap on how to settle disputes over often highly technical agency rules. Take the fishermen and their beef with the overfishing rule. Lower courts applied Chevron in those cases. First, the statute in question must be ambiguous or silent on the specific issue. The courts decided it was. The law didn't specify who pays for the observers.
If the statute is ambiguous, then the job of a reviewing court is to uphold any reasonable agency interpretation of the statute.
The courts concluded that a rule requiring fishing companies to pay for the observers was a reasonable interpretation of the law, so it sided with the agency.
Courts can't be experts on everything. Congress can't be experts on everything. So we're going to give the benefit of the doubt to people who have committed expertise in these areas.
In one really important passage, Justice Stevens said there's a big difference between agencies who are run by people who are appointed by a president who is accountable to the people versus judges who are the least accountable officials in government.
Over the years, the Supreme Court has used the Chevron deference to side with agencies on matters involving clean air, Social Security, and labor laws, to name a few.
It emboldened agencies. Now, they seem to be inviting us to be more aggressive in the way that we interpret our statutes.
Which brings us to today. 40 years later, the Supreme Court's conservative majority seems to believe that agencies have used Chevron to go too far.
Critics of Chevron situate their criticisms in separation of powers principles. And they say that agencies have obtained too much power through this doctrine, and that power should be redistributed to the courts, who under their view get to say what the law is. Personally, I'm not convinced by these criticisms.
Mergen says that by empowering agencies to make policy decisions, Chevron is our best tool to keep the laws up to date, in step with the ever-quickening pace of change in the world around us.
We have big issues. We have climate change. We have drastic income inequality. We have the threats posed by artificial intelligence. If agencies are afraid to act, we all have a lot to lose there.